Just imagine, it's the evening of 5th of August 2019. You are just scrolling your Instagram or your Facebook or your social media, anything, just going through the proper usage of internet. And suddenly, your mobile notification tells you that sorry, internet connections are not available in your locality, simply in your territory. What you will feel? Obviously displeased, obviously annoyed. But that actually happened in Kashmir exactly on the eve of 5th of August 2019, exactly after the abrogation of Article 370 by the Union Parliament. So there was a lady who was the editor of the local newspaper known as Kashmir Times, who argued that this internet shutdown by the authorities do troubles her Article 19 Clause 1 Subclause A along with Article 19 Clause 1 Subclause G, that is freedom of speech and expression along with the freedom to profess and practice any occupation, business, trade, service, job, etc. So these were the two fundamental rights as per Anuradha Bhasin, which was being violated due to this internet shutdown. And so comes in this landmark case, this landmark judgment that is named as Anuradha Bhasin versus Union of India 2019. Right? So guys, you're watching Study IQ as English. My name is Pravin Mishra, and in this video, we shall be discussing the core aspects of the whole news, of the whole case. So as you can see, once again, August 5, 2019, Kashmir, internet shutdown took place. Just in order to control the situation and just in order to avoid any kind of mishaps or mishappenings, the authorities did this act. And so Anuradha Bhasin stated that sorry, I can't handle this as it is the grave violation to my fundamental rights. So the petitioner's argument, as you can see here, the two articles, once again, Article 19 Clause 1 Subclause A and Article 19 Clause 1 Subclause G. That is once again freedom of speech and expression as well as the freedom to carry out any business, trade, occupation, etc. So she directly used her Article 32, that is the writ jurisdiction or the constitutional remedies, and approached the Supreme Court of India and demanded the reinstatement of her violated fundamental rights. And now this was a big question in front of the Supreme Court, that is it really justiciable? Is it really the act of authority that can be justified through the legislation as well as through the constitutional norms? And so the state's response comes in. The government was having a clear-cut answer that just in order to curb any kind of false news or any kind of fake images or any kind of misuse of the dark web that these terrorist organizations, they do often do, and just in order to control the situation, maintain the harmony, maintain the peace and tranquility, maintain the internal security, as well as balancing the sovereignty of the country, it was important. As we know that how the Kashmir Valley was in huge level of turbulence and turmoil during those ages when Article 370 was active. So as you can see, the government argued that the measures were necessary for public order as well as national security, given the volatile situation in Jammu and Kashmir. And so the state claimed that unrestricted internet, especially social media, could fuel violence, spread of false news, fake images, and also the huge level of intense misuse of the dark web. Right? And so they also maintained that the suspensions order were made through the proper legislation. Simply, they claimed the Telegraph Act of 1885 and the information technology rules that were amended in 2017 as well. Right? And so here we go with the issues that the courts were facing at that time. And the biggest question was, it's this: are the internet restrictions violative of fundamental rights of freedom of speech, along with the freedom of having any occupation, trade, or business? And so the next questions that followed, this one big question. What's that? As you can see, specifically, does the right to freedom of expression and the right to carry on one's profession can extend to internet? And now comes in the legal questions furthermore. That is the legality and limits of the internet suspension. Whether the government's power to suspend telecom services is being lawfully used. And second big question, whether such suspensions can indefinitely, or must be temporary, and what procedural safeguards should be applied. Okay, so first of all, what's the legality of such type of internet disruptions as well as disconnections? Secondly, how is it justified through the Telegraph Act? And apart from that, yes, are these shutdowns really impacting the fundamental rights guaranteed under Article 19 Clause 1 Subclause A along with 19 Clause 1 Subclause G? And so comes in the Supreme Court's verdict. right to have internet is your fundamental right. And guys, remember, you do not have any fundamental right. Let me repeat that. You do not have any fundamental right that comes without reasonable restrictions. Whether it is about your life, liberty, equality, discrimination, whatsoever. Each and every fundamental right possess the reasonable restriction as justified by the judiciary through the doctrine of reasonable restrictions. So internet is a fundamental right under Article 19 as well as Article 21. And so hence it will come with the reasonable restrictions. So what Supreme Court mandated? So it recognized that the internet is a medium through which the rights under Article 19 Clause 1 Subclause A, that is freedom of speech, and 19 Clause 1 Subclause G, that is profession or trade, are exercised. However, since it is a fundamental right, it can't have any kind of freestanding and absoluteness with itself. So fundamental right to the internet, it is there, but yes, for sure with restrictions. So rather, it stated the medium, that is the internet, enables fundamental rights. So for sure, restrictions on it must conform to the constitutional limits as well, just like your other freedoms, just like your other rights. And so Supreme Court mentioned here the test of proportionality. If you remember, in one of our videos, we discussed about the evolution of law. And in that, we discussed that how through the French Revolution, through the Japanese Revolution, through the era of Renaissance, that is Renaissance, after the Dark Ages, how the law system was created, how the legislative elements were created, and it was stated that law should be there, but it should pass the test of rationality, right? It should be valid. It should be logical. As in simply, the law should be having the reason for its existence. And so here comes in the test of proportionality. Whatever restrictions you are imposing on any fundamental right or any kind of a constitutional right, you will have to allow the citizens to have this answer that there is the proper reason behind it, that is the proportionality behind it. So as you can see what Supreme Court mandated, any restriction, let's say internet shutdown, must satisfy a proportionality test. As in simply, there should be a legitimate goal and a rational connection, that is the proper necessity and the balance to it as well. And so it further also argued about the blanket or indefinite shutdowns are not permissible. You cannot just be going and shutting down internet every now and then and be saying that, oh, it is suspended and we'll see when to reinstate it, when and if. You can't be simply going ahead with that. So what you needed, the court specifically required that suspension orders be reviewed periodically, simply every 7 working days under the applicable rule. Whether the Information Technology Act, whether the Telegraph Act of 1885, doesn't make any difference. So Supreme Court stated, go ahead, you have the authority to impose reasonable restrictions, but you must make sure that those restrictions are proportionate. Those restrictions are reasonable, logical, and valid. And simply speaking, you can't be just going ahead with indefinite shutdowns. But yes, shutdowns can take place in order to prevent any kind of mishappening, in order to just control and maintain the internal security, as well as assuring the sovereignty to the individuals, to the whole nation as well. Right? So this is it, guys, with regard to this case, that is Anuradha Bhasin versus Union of India. So guys, I hope you are absolutely crystal clear about the facts that we have discussed. And if you have any doubt in your mind, please feel free to comment into the comment section. And in the next video, we shall pick your comment and discuss it first, right? And guys, remember, if you are targeting Prelims 2026, it's late. Well, not exactly. We are on the threshold. But if you do a bit more delay, the train will take off the platform, right? So here we go. We are providing you what? The SIP, that is Success in Prelims program. What's this? We will be providing you 250 plus hours of live lectures. And in case you miss those live lectures, don't worry, you have the access to the recorded lectures. Don't worry if you have no idea about the examination, no idea about the subjects and anything. Relax. What do you need with yourself is just this SIP, because our expert faculties, expert teachers, expert mentors, they will be there to guide you. And so we are providing you 2 different types of subscriptions, that is the gold and the platinum. And remember, whatever subscription you take, along with the live lectures, you will be given 75 plus tests along with detailed discussion and evaluation, right? So guys, please remember 75 plus tests. You can go and do the basic research. No institution is going to provide you 75 tests. The maximum what you can get is 20, 30, maybe 40, but not 75. With detailed evaluation, detailed discussion will take place. So for sure, this program will compel you to crack the first stage, that is the preliminary examination. And see the price. Gold 5,999, platinum 7,999 only. But wait, we will provide you a bit more discount. I'm giving you the code. I'm giving you the trick with which, if you use this trick, you will be able to enroll yourself with the cheapest price with the highest discount. And what's the trick? It's the code PRV Live. So if you apply this promo code, remember what we will get: maximum discount on our subscription. And remember, guys, the admission to this is closing today, that is on 20th of November. Okay, everyone, so this is it with regard to this session. Quickly enroll yourself today and never miss this opportunity, right, everyone? And please do hit the subscribe button of our channel, StudyIQ as English, so that you are updated with the videos posted on this channel. As you see, the channel is occupied almost whole day, providing you the immense knowledge, the bunch of knowledge, right? So just hit the subscribe button and never miss an update from it. And yes, for any class notes, PDFs, links, discussion, quizzes, etc., feel free to connect here. That is the QR code of my Telegram channel with the channel name Praveen_StudyIQ. You can just search it or go on the search bar. You can just scan it or can go on the search bar and type the channel name Praveen_StudyIQ and connect. And also you can join me on my Instagram, that is with the username PraveenMishra_2107. Okay, everyone. So this is it with regard to this session. Thank you so much for joining. Bye bye. Good day. Take care. Keep studying well. Jai Hind. Jai Bharat.